The retaliation provisions of the anti-discrimination laws forbid taking an adverse action against you because you oppose discrimination or because you participated in a discrimination-related proceeding. Retaliation is the most common basis for a charge filed with the EEOC. It's almost as if employers don't like it when employees exercise their civil rights. Based on my experience as a federal investigator, it can sometimes be easier to prove retaliation than the discriminatory treatment that prompted the original complaint. Employees, applicants, and former employees are protected against retaliation for participating in an investigation or other discrimination-related proceeding. Participation includes filing a charge or lawsuit, testifying, and providing any other type of assistance. An employer cannot take an adverse action against an applicant, employee, or prior employee for opposing unlawful employment discrimination if the employee reasonably believes illegal discrimination has occurred. Requesting a reasonable accommodation is also a protected activity. Just about all forms of opposition to discrimination are protected activities, including complaining to anyone about employment discrimination, including management, the press, and other employees. Opposing discrimination against a coworker. Threatening to file a complaint or lawsuit alleging discrimination, or refusing to obey an order because of a reasonable belief that the order is discriminatory. The discrimination you opposed might not actually be illegal. As long as you had a reasonable belief that the alleged discriminatory employment practices were illegal, you are protected. Courts can have differing opinions of what constitutes a reasonable belief discrimination occurred. In one Supreme Court case, a complaint about a single sexually explicit remark that did not create a hostile work environment was not protected activity. Those that participate in a discrimination-related proceeding, like an investigation into another employee's complaint of discrimination, are protected regardless of whether they have a reasonable belief discrimination occurred. A future video will be devoted to techniques and strategies for making an internal complaint of discrimination. Your employer cannot retaliate against your family member because of your protected activity, nor take an adverse action against you because it believes you will oppose discrimination or participate in a discrimination-related proceeding in the future. Carefully choose your method of opposing discrimination. You don't want to give your employer a legitimate reason to fire you. Sending a company-wide email without supervisory approval could be a terminable offense. If so, and you're determined to do it anyway, consider first asking for approval to have a meeting with other employees to discuss discrimination. After widely distributing your meeting invitation, you might still be fired for insubordination, but you will receive more sympathy for your complaint of retaliation. A managerial official or company EEO officer who publicly opposes discrimination can compromise their ability to perform their job. It's time for a story about when circumstances seemed extreme enough to justify dramatic action. I love a good story. I'm telling the story? This might not shock you, but as a cis, white, middle-class male, I haven't experienced a whole lot of discrimination, but I have had a taste of retaliation. I was working at a summer camp where we weren't supposed to talk about salary, but of course I did, and found out that I was getting paid more than women with more experience and more seniority. I brought it to the attention of my male managers, but they didn't care. They already knew. So I got most of the staff to sign a petition with their salary and experience and eventually organized a strike. The night before the strike, I had a meeting with the executive director who agreed to redo their salary structure. But after the meeting, my male manager stripped me of my plum assignment to chaperone the big end-of-year trip to Disneyland, and I was denied hire the following year. There are 3 things you must prove to establish a retaliation case. Your employer knew of your protected activity, opposing discrimination or participating in a discrimination-related proceeding. Your employer subjected you to an adverse action. A causal link exists between the adverse action and your protected activity. Proving your employer knew of your participation in a discrimination-related proceeding is usually not difficult. The same cannot be said about opposition to discrimination. When you verbally oppose discrimination, later proving the existence of this conversation may be difficult. You can avoid this by following up the conversation with a professional email to your employer that references your opposition, like, "I'm sorry we cannot reach an agreement yesterday regarding my concern that I am being denied a promotion based on my race." You should be able to prove you experience an adverse action without much difficulty. Proving a connection between the adverse action and the protected activity is the biggest challenge in a retaliation case. The most common way to show a correlation is through the timing of the adverse action. If the adverse action occurred soon after the protected activity, like when I was pulled from the Disneyland trip, the link is clear. If the adverse action occurred much later, like when I was denied hire the following summer, then you will need direct evidence or evidence that you were treated quite differently than others. Any adverse action taken because of a protected activity is prohibited. The employer does not have to be acting maliciously. A policy that an employer will not conduct an internal investigation in response to a discrimination complaint once an employee complains to a governmental agency is considered retaliation. The employee is being penalized for participating in a discrimination-related proceeding. Typical forms of retaliation for current employees are in-depth probes of an employee's work history, increased scrutiny at work, and creation of a paper trail. These methods are used to fabricate justifications for disciplinary action or termination. For former employees, common forms of retaliation are providing poor recommendations and contesting claims for unemployment compensation. Trivial punishments are not significant enough to be considered adverse actions, like a temporary transfer from an office to a cubicle. In addition to barring retaliation, the Americans with Disabilities Act also prohibits coercing, intimidating, threatening, or interfering with anyone exercising rights protected by the ADA. This provision creates a broader protection for employees. For example, your employer cannot coerce you to forego a reasonable accommodation or take an adverse action against you for assisting with another employee's request for a reasonable accommodation. Now you know what you need to prove when you've experienced retaliation. The second half of this series is all about how to prove discrimination. But there's one more video in the first half. It's about legal loopholes, like how many employees your employer must have, and when it's too late to file a complaint. Check out the list at the beginning of the next video and make sure there are no obstacles that could undermine your legal protections. If you've experienced retaliation and have any tips that might be helpful to others, please leave them in the comments below. Retaliation is a risk when fighting for your rights or another's. For some, the risks are not worth the potential benefits. For others, the risks are acceptable only because the alternative is less acceptable, living with a diminished sense of personal integrity. Thanks for tuning in.